is responsible?
The acts of a judge issuing a nationwide injunction acts as a one-man or one-woman council of revision. The second aspect of it, nationwide injunctions that's inconsistent with our American legal system, is that it inflates the role of the individual district court judge within the judicial structure. The Constitution empowers Congress to create lower federal courts, and in designing a system of 93 judicial districts and 12 regional circuits, Congress set clear geographical limits on lower court jurisdiction. In our system, district court rulings do not bind other judges, even other judges in the same district. This system has many virtues. It creates checks and balances within the judiciary itself, and it encourages what former D.C. Circuit Judge Harold Leventhal called percolation, the process by which many lower courts offer their views on legal issues before higher courts resolve them. This process of percolation is not just a good idea, it's the very embodiment of our common law tradition. In that great tradition, governing legal principles emerged from a scattershot of precedent that involved multiple cases over many years, decided by multiple judges working through legal issues and refining their views. When a nationwide injunction issues against the government, it short-circuits that process. Because such injunctions prevent enforcement against anyone, anywhere, they overshadow related litigation in other courts. After all, even if the government prevails in every other case, a nationwide injunction still prevents all enforcement of the law. It thus gives a single judge the unprecedented power to render irrelevant the decisions of every other jurisdiction in the country. This is not a hypothetical occurrence. In litigation over the president's policy on transgender military service, the government won a victory in the D.C. Circuit. Yet because district courts in California and Washington had enjoined the policy nationwide, the D.C. Circuit's decision has no practical effect. The government could not implement the policy until the Supreme Court acted. That is not the only example. The Ninth Circuit recently ordered briefing on whether a nationwide injunction from Pennsylvania District Court mooted the appeal of an injunction from within the Ninth Circuit. Giving a single district court judge such outsized power is irreconcilable with the structure of our judicial system. It not only allows district courts to wield unprecedented power, it also allows district court to wield it asymmetrically. When a court denies a nationwide injunction, the decision does not affect other cases. But when a court grants a nationwide injunction, it renders all other litigation on the issue largely irrelevant. Think about what this means for the government. When Congress passes a statute or the president implements a policy that is challenged in multiple courts, the government has to run the table. We must win every case. The challengers, however, just have to find that one district court judge out of the available 600 willing to enter a nationwide injunction. One judge can, in effect, cancel the policy with a stroke of the pen. Even the Chief Justice of the United States must convince at least 4 other justices to bind the federal government nationwide. Third, nationwide injunctions undermine public confidence in the judiciary. When a single judge can freeze policies nationwide, it's not hard to predict what plaintiffs will do. In Professor Bray's memorable phrase, they shop until the statute drops. Requests for nationwide injunctions thus flooded Texas district courts during the Obama administration, while similar requests have landed in California and New York during the Trump administration. I'm not here to question any judge's motivation, but even assuming all good faith, the appearance of forum shopping is inescapable and damaging to the ideal of an impartial judiciary. The consequences will be far-reaching and could include politicizing the district court confirmation process in ways similar to what we have seen for the courts of appeal and the Supreme Court, and none of us should want that to happen. Fourth, nationwide injunctions create unnecessary and unhelpful emergencies. When a nationwide injunction constrains a significant executive policy, the Justice Department has little choice but to seek emergency relief. No one benefits from emergency litigation, not the government, not the plaintiffs, not the courts, not the American people. But the alternative is for a government to wait months or years for appeals to run their course before the executive may implement its policies at all. Finally, nationwide injunctions conflict with the litigation system that Congress has chosen as the mechanism for aggregate litigation. One of the few potential defenses of nationwide injunctions is that they promote uniformity. Of course, we value uniformity in our legal system, but we already have ways to achieve it, usually through review by the Supreme Court on a writ of certiorari after an issue has percolated through the lower courts. When the Supreme Court issues a nationwide ruling in that posture, we have more confidence it is due to the preceding efforts in the lower courts. Nationwide injunctions turn that process on its head, and they treat the first case like it is the last case. I mean, after all, why do we have 3 judges on the intermediate appellate level and then 9 justices on the Supreme Court? It's because of the significance of that last decision by the Supreme Court adopting a uniform rule for the country. Congress and the Federal Rules Committee have also designed mechanisms for aggregate litigation where appropriate, but none authorizes nationwide injunctions. Consider Federal Rules of Civil Procedure 23, which allows plaintiffs to bring class actions on behalf of unnamed parties, sometimes across the nation. Still, they must meet a series of procedural and substantive requirements, including that class members share typical claims and that the named plaintiffs will adequately represent the members of the class. The rules also provide, in many cases, for absent class members to receive notice of the action and the opportunity to opt out. Members of the class are also generally bound by the district court's judgment and precluded from relitigating in different courts. Nationwide injunctions do not work that way. To end where I began, I raised the problem of nationwide injunctions as a matter not of partisanship, but of the rule of law. One can easily imagine a future administration's policy, say on climate change or employee rights, freezing under nationwide injunctions for years on end. Imagine, for example, if a new administration were to abandon a zero-tolerance policy on immigration offenses only to see a district court order it back in place. One can draw up countless of other scenarios. I don't want to see any of them. Nationwide injunctions undermine the democratic process, depart from our history and tradition, violate constitutional principles, and impede sound judicial administration, all at the cost of public confidence in our institutions, and particularly in our courts as apolitical decision makers dispassionately applying objective law. The Justice Department will continue to oppose nationwide injunctions as we have across administrations of different ideological perspectives. I hope you will make your voices heard on this issue too. At a time of deep differences on so many legal and policy issues, this is one area where I hope lawyers and citizens can agree. Once again, thank you for your invitation to speak tonight and for all you do for the legal profession.
Thank you, Attorney General Barr. There's a long relation relationship between the American Law Institute and the United States Department of Justice and all of our justice agencies around the country. And whatever our different views may be, I think we all seek justice, and we respect those who seek it as well. So thank you, and we appreciate that you gave us a serious talk, even though you evaded the very difficult questions that are raised by the UCC Section 2. Now, tomorrow,